Good evening, everybody. Kind of letting you have a chance to come into the room. We'll get started here shortly. Well, good evening. My name is Rich Hoyt. I am co-chair of the One Health Working Group at Delaware Valley University, or as we call it, DelVal. For most of you, I anticipate that you are either a student at DelVal or you certainly are well-versed in who DelVal is. But for those who have not heard of our One Health working group, I'd like to give you a little bit of insight into it. There's a formal definition at the bottom of this slide, but I have a more simple way of looking at this. We've got one planet, and we've got one future with this planet, and therefore we're sharing an environment and the homes of animals that besides ourselves that are dependent on what we're doing. We in turn are dependent on what's happening to them as well. So it would behoove us, no matter what our majors are or what our disciplines are, to pay attention to what's going on around us and how our actions impact the environment, impact animals, and how those kinds of actions may come back and impact us as well. At DelVal, we do this in a couple of ways. We do it partially through our coursework. There are One Health programs around the country, but mostly these are oriented towards either human health or veterinary health or environmental health. But at DelVal, we're taking a much broader view on this. And we have over 20 courses that actually involve One Health within the coursework. Not so much saying we're focusing on One Health, but recognizing that no matter what your discipline is, you're going to be much better off in your career if you approach it from a transdisciplinary approach. That you recognize that other people with different experiences, with different backgrounds, can greatly benefit your own work and your own lives. And that if you can leave DelVal, or you could go into your lives and respect the opinions of others and listen to the opinions of others and work together to come to solutions, I think you'll find that things work out much better. In addition, we certainly would encourage students, particularly our student research programs, to engage in cross-disciplinary kinds of activities. Look at things from somebody else's point of view. And then finally, this seminar, amongst all the others that we do each semester, is part of our outreach. Just trying to bring a number of different topics to the stage, to have great speakers like we have this evening, to present maybe something that you didn't know a whole lot about before, but is certainly going to be valuable for you to be aware of. So at this time, I'm going to close down my slides here and introduce our speaker for this evening. If he still has the ability to share, yes, good. So I am extremely pleased to introduce our speaker for this evening. Professor Royal Gardner is an internationally recognized expert in wetland law and policy. Recent projects include testifying before a World Bank arbitration panel, advising the government of Oman regarding wetland policy, co-authoring amicus briefs on behalf of environmental scientists, and creating interdisciplinary courses that facilitate discourse among experienced scientists, policymakers, and students. And with the flyer that you received for this event, you would have seen that he is also the author of a book that has the same title of his presentation this evening. And Island Press has agreed to provide a 30% discount on that book if you use the code webinar when you go to their site and purchase the book. So I am very happy to have Roy with us this evening, and my cat who's now trying to come up on. Thank you, and it's all yours, Roy.
Thanks so much, Reg, and thanks for the kind introduction and the opportunity to be with you. And before I begin, I just want to emphasize, yeah, I totally agree with you in terms of the importance of a transdisciplinary approach. I have been very fortunate in my career to work with wetland scientists in the United States and all over the world, and I have learned so much from them. But if we are to make an advance in the policy area, in the legal area, it needs to be informed by science. And I'll talk a little bit about that today. So my book is Waters of the United States, POTUS, SCOTUS, WOTUS, and the Politics of a National Resource. And probably most of you know POTUS is an acronym for President of the United States. Uh, Perhaps a little less familiar is SCOTUS, which is Supreme Court of the United States. Actually, as an acronym, SCOTUS came first. It was used by telegraph operators in the 1870s, and about 20 years later, they adopted it for the president. Fewer people are familiar with the acronym WOTUS, but that's one that may affect you more directly, certainly on a daily basis, and that stands for Waters of the United States. And that is a statutory term in the Clean Water Act, the federal law that is our primary mechanism for water quality in the United States. And at the heart of the Clean Water Act is this concept of WOTUS. If a water body is considered to be a water of the United States, then it's protected by the Clean Water Act. If it is not a WOTUS, then it is not protected federally. So I want to give a little background. The Clean Water Act was enacted in 1972, but I want to establish my environmental bona fides here. So that is a picture of me back around Earth Day, 1972. I'm there with the somewhat stunned look on my face. It's a shame that we don't have it in color because, as I recall, that was a sky blue turtleneck that I'm wearing with the vest. That was quite the style in the 1970s. My brother and sister are there as well. We won a photo essay contest for our respective grades, sponsored by the Conservation Club in our elementary school. And the theme was man's use and abuse of the environment. Uh, we had a little bit of an advantage because our dad worked for Kodak. Uh, but I just wanted to show this because this to demonstrate that my environmental interest, my environmental commitment actually predated the Clean Water Act, which was enacted in 1972. So what I'd like to do with our time this evening is I'll give you a little bit of history about the Clean Water Act and some background about it. And then we'll talk about all of the different WOTUS rules and litigation that followed. So when I talk about rulemaking, what I'm going to be referring to is the development of regulations by agencies. So agencies such as the U.S. Environmental Protection Agency and the U.S. Army Corps of Engineers. Over time, they have issued regulations that define which waters are protected and which waters are not. And every time they do, there's litigation that follows. And one of the most significant cases to come down is Sackett versus U.S. Environmental Protection Agency, which was issued by the Supreme Court, SCOTUS, in May of 2023. And it was a particularly bad decision if you are a fan of clean water. And then we'll conclude and sort of talk about what's the implications. What's next? What does this decision mean? So to go back in history, federal involvement in navigable waters actually dates back to the founding. Rivers were channels of commerce. And Congress directed the U.S. Army Corps of Engineers to keep the rivers open for purposes of commerce, but also for military purposes. And eventually, in the late 1800s, Congress adopted a series of laws called the Rivers and Harbors Act that gave the authority to the Corps of Engineers to regulate what types of structures were built over rivers, because that could impede navigation, and anybody who wanted to fill in these rivers or have any other type of structure on these rivers that might impede the navigable capacity of those waters. And so the waters that the federal government was most concerned about at this point were what we now call traditional navigable waters. And that encompasses waters that are navigable in fact. That means that waters that are actually used in commerce. But it also includes waters that were once navigable. So once the concept is once navigable, always navigable. It also included certain waters that could be deemed navigable if there were some improvements made to it in terms of passage. So almost navigable waters were also covered. And then waters that are subject to the ebb and flow of the tide are also considered to be traditional navigable waters. So if we look at that on a landscape, what we're talking about would be these types of water bodies. A river is your traditional navigable water, but it also includes the territorial seas off the coast, and then it could also include coastal wetlands if they are subject to the ebb and flow of the tide. Now, the focus of the federal government at this time in history was navigation. They really only worried about these waters or activities in these waters to the extent that they interfered with navigation. Questions of water quality were left to the states. But over time, it became apparent that there needed to be a federal role with respect to water quality. Why was that? Well, in the first instance, you could have private lawsuits, private nuisance actions, or public nuisance cases brought against polluters, but that litigation is after the fact. So the damage has already been done. And it's also expensive to litigate. So it's not a very effective or efficient way to promote water quality. What about state regulation? Well, that's traditionally states have had the primary authority to regulate activities with respect to water quality. States were primarily responsible for water quality, but we saw that states did not do a very good job. And this is the classic photo of a fire in the Cuyahoga River in Ohio. Um, and it became emblematic in terms of the state's failure to regulate uh, uh, industrial discharges. Part of the reason is states were a little bit reluctant to regulate the businesses that were in their states and their communities because they were afraid if they regulated too strictly, well, they would leave. So there was a bit of a race to the bottom and a lack of regulation of polluters. So this led Congress in 1972 to totally rewrite the way that it had been dealing with water quality and to adopt what we know, what we refer to as cooperative federalism, that both the feds, the federal government, and the states would work together to promote water quality. So it was adopted in October of 1972, which is actually remarkable for a couple of reasons. One, it was over President Nixon's veto. President Nixon thought that it would be too expensive, so he vetoed it, but Congress overrode his veto 1 month before Nixon won a landslide election. So that was remarkable. But what was also remarkable is that here you had Congress actually working and putting out major legislation 1 month before an election. It's a different time. Now, the Clean Water Act itself, one of the things that it does, it sets a goal of the overall objective of the act is to restore and maintain the physical, chemical, and biological integrity of the nation's waters. And the way that it attempts to do that is first with a prohibition. It says it's prohibited to discharge from a point source pollutants to navigable waters unless you have a permit. So there's a flat prohibition on polluting waters unless you have a permit. There are two main types of permits. One of them is called a Section 402 permit, and the other is a Section 404 permit. It deals with different types of pollutants. So if you have, let's say, a chemical pollutant coming out of the end of a pipe from a manufacturing facility, that would require a Section 402 permit issued by the EPA or a state with an EPA approved program. The state could take it over. If, on the other hand, you were discharging what's called dredged or fill material, so not something that's contaminated, but it could be clean earth that you are discharging into the water body, that actually requires a permit from the U.S. Army Corps of Engineers. Now you might say, wait, why is dirt considered a pollutant? How is clean earth a pollutant? Well, the sedimentation can affect water quality in a number of ways, and if you are filling in a water body to eliminate it, and you eliminate that water body from the landscape, there are obviously environmental impacts associated with that as well. So the idea was for these discrete conveyances of pollutants, whether from a pipe or a dump truck, that these would require a federal permit. The states could take over the federal program if they wanted to, but the feds were setting a floor, a minimum level of protection, and the states could regulate more strictly if they wanted to. Now, the Clean Water Act also, with respect to non-point source discharges, non-point source discharges would be diffuse runoff from agricultural fields, for example. So not considered to be a point source, but rather a non-point source. That was left entirely to the states. And there's a relationship with the Clean Water Act and other environmental laws as well. So often, if you need to get a Clean Water Act permit, that might trigger an environmental assessment under the National Environmental Policy Act, or perhaps the Endangered Species Act may also be implicated. Then we can talk more about that in the question and answer period if you are interested. So Congress sets up this system where they say, all right, you're going to need a permit if you're going to discharge a pollutant from a point source to a navigable water. All right, well, what does navigable water mean? Well, they defined it as waters of the United States. Well, what does waters of the United States mean? Congress, in the law, didn't give any additional information. And so the Corps of Engineers issued a regulation that initially defined waters of the United States the same way that the Corps had always been regulating traditional navigable waters. So initially, the Corps of Engineers interpreted this term, waters of the United States, to simply mean traditional navigable waters. Navigable in fact, navigable in the past, almost navigable, those waters subject to the ebb and flow of the tide. Environmental groups brought a lawsuit to say, no, Congress meant something broader. And indeed, if you look at the legislative history of the Clean Water Act, the House defined navigable waters to be navigable waters of the United States. And the Senate version of the bill eliminated the word navigable and just said, nope, navigable waters means waters of the United States. And in the conference report, the conference, when the House and the Senate got together to try to reconcile the differences, they went with the Senate version, and they said, look, we want the Corps of Engineers and the EPA to regulate to the fullest extent permitted by the Commerce Clause. So the courts at this point told the Corps of Engineers, go back and rewrite your regulations and regulate these waters to the fullest extent permitted by the Commerce Clause. And so the agencies did this, both the Corps of Engineers and the EPA. They issued regulations, and there's a particular process that they issue regulations where it goes through a notice and comment process where the public has an opportunity to comment on these proposed rules or regulations. And at the end of the day, this is how it looked in the mid 1980s. You had obviously the rivers and territorial sea and coastal wetlands covered, but also non-navigable tributaries, wetlands that were adjacent to those non-navigable tributaries, and then also other waters, isolated waters, so-called isolated waters. In the law, we sometimes refer to it as isolated waters, but scientists will tell you waters are not isolated. And in the law, we like to put things in boxes. But these so-called isolated waters would be regulated to the extent that there was a commerce clause connection, some connection to commerce. And so these rules, this interpretation of waters of the United States, and remember, this means that if you're going to discharge a pollutant into any of these waters, you need to get a federal permit. Well, the regulated community, which is a nice term for polluters, uh, they challenged these definitions in a series of cases, actually in a trilogy of cases, in the Supreme Court. And so we have WOTUS in the SCOTUS. And the first of this trilogy was a case called Riverside Bayview Homes. And this involved, this was up in Michigan, where a developer was seeking to fill in some wetlands to build some homes, and it involved wetlands that were adjacent to traditional navigable waters, and the Supreme Court recognized that wetlands are very important for water quality, that they filter out pollutants. They're viewed as nature's kidneys. If you remove wetlands from the landscape, you are removing that water quality function. But wetlands also provide other functions and benefits to people as well. There is a flood control function. So wetlands can act like sponges, and they can absorb flood waters and slowly release them. So if you fill in wetlands, you tend to see in those areas flood damage exacerbated because you've eliminated that flood storage capacity. And wetlands, as you may know, also provide very important habitat for many different species, including very commercially valuable species. Most seafood that we eat depend or live part of their life or depend on healthy wetlands. So the Supreme Court in this particular case was unanimous, 9-0. They all agreed that it was reasonable for the federal agencies, for the Corps and the EPA to protect these wetlands. And they deferred to the agency's scientific expertise. And they said, well, because it's difficult sometimes to tell where water ends, where the wetland ends and land begins, we're going to trust the judgment of the technical experts. So that was the first big test of WOTUS in the Supreme Court. A number of years later, a case arose out of Illinois, and this is called SWANC, which stands for Solid Waste Agency of Northern Cook County. So this was it was a consortium of towns that was looking to find a place for non-hazardous waste. They wanted to create a landfill, and they found an area that they wanted to fill in, but they were going to be filling in some wetlands and some ponds. And the Corps of Engineers said, well, this is actually providing some very good habitat for some migratory birds. And we have a rule that if migratory birds give us a commerce connection. So you need to apply for a permit. So you might say, wait a minute, wait a minute, Gardner. Birds don't buy anything. Birds do not engage in commerce. How can there be a commerce connection? Well, birds themselves may not engage in commerce, but certainly people spend billions of dollars a year to bird watch or to hunt birds. And so, to the extent that you destroy their habitat, you are affecting bird populations and thereby affecting commerce. That was the argument, anyway, that the Corps of Engineers and the EPA were making. But the Supreme Court said, we're a little concerned here because these decisions involving isolated waters, that sounds like to us more like a land use decision. And traditionally, that's the responsibility for states. So if Congress wants the federal agencies, the Corps of Engineers and the EPA, to regulate these isolated waters, protect these isolated waters, they need to be clear. So Congress needs to be very clear when intruding onto these areas that are traditionally within the province of the states. And the court concluded that Congress is not sufficiently clear, and thus it was unreasonable for the agencies to regulate these and try to protect these isolated waters. Which now brings us to this case, Rapanos, which is a complicated decision because there was no majority decision. There are 9 justices usually sitting on the Supreme Court, so majority is 5. If you get 5 judges that agree on the decision and the reasoning, you have a majority opinion. That was not the case in Rapanos. It split 4-4-1. So on one side, you had Justice Scalia, who was advocating for a very restrictive interpretation of WOTUS that would not cover these non-navigable tributaries or wetlands adjacent to non-navigable tributaries. On the other end of the continuum, you had Justice Stevens arguing that, hey, as long as there's a hydrological connection, we should defer to the agency's technical expertise. And then in the middle, you had Justice Kennedy, who for a while was the swing vote on the Supreme Court. And he did not agree with Justice Scalia and the restrictive interpretation of WOTUS, and he did not agree with Justice Stevens and the more expansive interpretation of WOTUS. Instead, he came up with his own interpretation. So, Justice Scalia's plurality opinion, as it is called, said the only waters that are covered are those that are relatively permanent, standing, or continuously flowing bodies of water, such as oceans, rivers, and lakes. Note, wetlands are not mentioned there. He went on to say that the Clean Water Act protects only those wetlands that have a continuous surface connection to another body of water that qualifies in its own right as a water of the United States. So Justice Kennedy, as I said, disagreed with that. He disagreed with the reasoning, and he also disagreed with the tone, because Justice Scalia was a little snarky. And Justice Kennedy instead suggested, wetlands can be jurisdictional. They can be protected under the Clean Water Act if they possess a significant nexus to a traditional navigable water. They didn't have to have a continuous surface connection because often wetlands will have a subsurface connection, a groundwater connection, and can provide water quality functions to that larger water body through groundwater. Um, and so Justice Kennedy felt, okay, well, we should remand the case back down for a determination about whether these wetlands had a significant nexus to a larger water body. And so he voted with Justice Scalia and the other justices to send it down. But there was no majority opinion. So we've got everybody agreeing it's okay to regulate wetlands adjacent to traditional navigable waters. We have a 5-4 decision saying that, well, at least you can't use migratory birds as a justification to regulate, to protect these wetlands. And then it's just totally split with respect to these other water bodies in the middle. Eh, so what's the agency to do? How do they deal with this plurality opinion that has no majority opinion for it to follow? Um, well, what they did is they issued guidance. And this is a good tip for you out there who may get into law and policy area. When you think of the law, you've got the Constitution, you've got statutes, you have agency regulations. Um, but there's agencies will also issue these things called guidance documents. And guidance documents do not have the force of law. They're not legally binding, but they're very legally relevant. If you ever if you're ever dealing with agencies, you want to know if there are any guidance documents out there because it tells you how the agencies are interpreting the regulations or interpreting the statute or how they might usually exercise their discretion. So these are important documents. Um, and so after Rapanos, the agencies issued some guidance that said, hey, you know what? We're going to go down the middle. We're going to go with what Justice Kennedy was saying because the agencies knew that if they had Justice Kennedy's vote and it ever got back up to the Supreme Court, they were going to win, right? Because if there was a significant nexus, they had Kennedy plus Stevens and the other dissenters. If there was no significant nexus, they knew they had Kennedy plus the Scalia team. So that was a reasonable way to proceed in this area of ambiguity. Um, Jump forward to 2015, and so some of you may remember that President Obama was president at that time. And so at that point, the agencies actually went through a rulemaking and issued a regulation, essentially codifying this approach, this significant nexus approach. Um, Agencies, though, are headed up by political appointees, appointed by the president, appointed by POTUS. So when there is a change in administration, there is a change in political leadership of the agencies, and thus there may be a change in the regulations, a change in the interpretation of the statutes. And indeed, that's what we saw when the Trump administration came in. And so one of the first things that President Trump did when he came into office the first time was to call on the agencies to get rid of the Obama rule, the Clean Water Rule, and that's what they did. And in its place, the Trump administration issued what was called the Navigable Waters Protection Rule, which was pretty restrictive, did not protect as many waters as the Obama rule. But of course, then we had another election. The Biden administration came in, got rid of the Trump rule, put in its own rule. But as regular as the tide, inevitably, after every rulemaking, litigation follows. And one such case is this case of Sackett versus US EPA. And so the wetlands in this case, the wetlands in question here, were about 300 feet away from Priest Lake in Idaho. And so the Sacketts wanted to build a home there. They wanted to fill in this wetland to build a house. The wetlands had a shallow subsurface connection to Priest Lake, which almost everybody, except for Justice Thomas, accepts that this is a traditional navigable water. So, applying the significant nexus test, the agencies concluded that these wetlands are jurisdictional. They should be protected under the Clean Water Act, and the trial court and the Court of Appeals agreed. The Supreme Court then decided to hear the case to consider whether and to what extent wetlands are covered by the Clean Water Act. That is, are wetlands waters of the United States? This was the Sackett's position in their brief. They said that wetlands are not even waters. So this is a picture of my students and me standing in what is apparently not water. This is Cypress Dome in the Western Everglades in Big Cypress National Preserve, where I like to take my students. In a big case like this, often you will have interested stakeholders. They're not parties, but they're interested in the outcome. They will file amicus briefs or amici briefs in support of one party or another. And so many industry groups filed briefs urging the Supreme Court to limit the protections of the Clean Water Act. There were some amici briefs that were also filed in favor of the US EPA's position, including one that my legal team and I filed on behalf of 12 scientific societies to inform the court about the consequences of adopting a restrictive view of what waters are protected. I actually had the opportunity to attend oral arguments. This was the first one that was open to the public post-COVID. It was also Justice Ketanji Brown Jackson's first oral argument. So we had to get there early to get a seat. And I urge you, if you ever have an opportunity to watch an oral argument at the Supreme Court, you should do so. Really fascinating. Based on the questions from the justices, it was a little unclear how they might rule. We went in thinking, oh, it's going to be bad, but wasn't quite sure. But alas, in the end, the court unanimously rejected the significant nexus test, and there was a majority opinion written by Justice Alito that adopted Justice Scalia's plurality opinion from Rapanos. There were separate concurrences by some other justices, but since there's a majority opinion, those are largely academic. So what's the test that was adopted, right? Again, it's that first that waters are only those that are relatively permanent, standing, or continuously flowing, such as streams, oceans, rivers, and lakes, and wetlands, sadly, are not on that list. The court said that wetlands are only protected if they have a continuous surface connection with to another water that is a WOTUS in its own right, so that the wetland and the waters are indistinguishable from each other. Indistinguishable from each other. All right, so what does this eliminate from the landscape? Let's see. In my view, non-floodplain wetlands, these do not have continuous surface connections, so they're out. This is nationwide. Prairie potholes, incredibly important for migratory waterfowl. Precosins, vernal pools, Carolina and Delmarva bays. Also, riparian floodplain wetlands that have a surface connection to ephemeral streams. Those are out because ephemeral streams are no longer covered. Ephemeral, by definition, they're not relatively permanent water, so they are not going to be covered anymore, and that has dramatic impacts out in the arid West, where 80 to 90% of streams are not perennial. Also out are riparian or floodplain wetlands that only have a groundwater or a subsurface connection to a traditional navigable water. Now, the US EPA, initially at least, estimated that this eliminates up to 63% of protections for wetlands across the country. But I actually think that's an underestimate, because it doesn't take into account this indistinguishable concept that the court was talking about. It's like, what does that mean, right? They said that the court said that Clean Water Act protections only extend to wetlands that are, as a practical matter, indistinguishable from a WOTUS, where it's difficult to determine where the water ends and the wetland begins. And this is not mere rhetorical flourish. It's a central part of the court's holding. We tried to flag this for the court in our amicus brief. We were actually the only one, I think, that addressed it in any detail. There's there's nothing in the scientific literature or in practice that suggests that it's difficult to determine the boundaries between a wetland and a stream. Indeed, if you talk to wetland consultants, delineators, that's what they do. They they make delineations on a regular basis, and they say, hey, here's where the wetland ends and here's where the stream begins. But under the Supreme Court's reasoning, if you can delineate a wetland, that means you can distinguish it from other waters. And if you can distinguish it from other waters, well, then it's not indistinguishable and it's not WOTUS, and therefore it's not protected by the Clean Water Act. Now, to be clear, I think this indistinguishable requirement has no basis in statute, in science, or in practice, but that's what the U.S. Supreme Court has decreed. And so that's what we're going to have to follow. So, is this Cypress Dome in the Western Everglades, where I really enjoy taking my students, is this still considered to be a water of the United States? Nope. It dries out during the year, so there's no continuous surface connection to a larger water body. And also, there is a road, as you can see here on the map, that separates it from other waters. It's distinguishable from other waters, and thus, under the Supreme Court's uh, reasoning, it doesn't qualify as a water of the United States. So larger scale, what does this look like? I understand we might have some folks from Florida joining us today, so you'll enjoy this. So consider the greater Everglades ecosystem. Um, I was part of a team with my Stetson University colleagues and the National Parks Conservation Association that examined the issue of the impact of Sackett, the Supreme Court case on Clean Water Act protections. And this map shows the approximate coverage of the Clean Water Act before the court's decision. This is it after the court's decision. This is applying the indistinguishable test. So here it is in color. So if you get the book, which I hope you enjoy, if you do, pictures are in black and white. But here for you, this special presentation, we have it in color. But as you can see, it's a rather dramatic reduction in Clean Water Act jurisdiction. And our findings, our conclusions are consistent with what other models and scenarios that are being developed by others, including the Environmental Defense Fund. So, what does this mean? Well, courts are beginning to apply, lower courts are beginning to apply this indistinguishable test, and concluding that nope, that you don't need a permit, you don't need a federal permit anyway to fill in and destroy these wetlands. One of the points I want to emphasize here is that the Supreme Court's decision actually is more restrictive than the Trump rule, than the Navigable Waters Protection Rule. Um, the the first Trump administration's rule covered more waters than the Supreme Court's decision did. Um, this decision means that there's no need for a Clean Water Act permit to fill the vast majority of wetlands and many streams. So, from a federal perspective, millions of acres of wetlands and millions of miles of streams are no longer protected. This is essentially a near extinction event for federal regulation of freshwater wetlands under the Clean Water Act. Now, one of the reasons that the regulated community went after wetlands um, was because they don't like the 404 program, the Section 404 program, where you have to get a permit from the U.S. Army Corps of Engineers. And so they 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 attacked WOTUS because they didn't like 404. But WOTUS is the jurisdictional hook for all aspects of the Clean Water Act. So it also means that you can now dump pollutants into um, other streams, or chemical pollutants into wetlands, and you don't need a federal permit. Um, and there are other parts of the Clean Water Act that are affected as well. So, under the Clean Water Act, when the feds are issuing a permit or granting a license to discharge for discharges into a water of the United States, the states have the opportunity to weigh in and veto that project and say yes or no. Well, if it's not a WOTUS, then the states don't that Clean Water Act Section 401 no longer applies. The water quality standards in the Clean Water Act, total maximum daily loads, they do not apply to non-WOTUS. Um, there are also uh, incidental uh, casualties to others, such as those in the mitigation banking industry. I don't know if you're familiar with this business of restoration. That there is an entire business of restoration that has grown. It's a couple $1 billion industry where they restore wetlands and streams to offset, to compensate for the damage done to permitted impacts, to permitted projects. And so when somebody who has a federal permit, uh, sometimes the agency will say, well, you need to, if you're going to fill in 10 acres of wetlands, you need to restore 10 acres. Well, there's this whole business of restoration experts who restore wetlands, generating credits that they then sell to these developers or permittees. But the whole driver for that program in many states is the Clean Water Act. And so if there's no driver, if there's no need to get a permit, there's no need to get offsets, and therefore there's no need to buy permits. So this can seriously harm that industry as well. And so really when it comes down to it, the bottom line is that the pendulum has shifted. And that at one point, it was the responsibility of state and local governments to protect wetlands and certain streams, and then it shifted to a model of cooperative federalism where the federal government was heavily involved, but it has now shifted back to where the primary responsibility for wetland protection, it lies now with state and local governments. Congress, if it wanted to, could step in and fix this, but I think we all know Congress is not going to do that. So the real battles are going to be at the state and the local level. And so some states are stepping up. So New York and Colorado, for example, have adopted wetland regulation protection rules after Sackett or in anticipation of Sackett. You have other states where there's movement, such as New Mexico or Illinois. But then you have other states that sort of said, oh, well, if the feds are backing off, we're going to reduce our state protections. So North Carolina has done that. Sometimes as we see federal protections uh, contract, we also see state protections. And and that's why it is so critical about who our leaders are at every level of government. And now with respect to wetland protections at the state and local level. And so that's why it's critical that if you care about these issues, that you vote in every election, not just for national elections, but for every election. And it can matter. And I'll conclude with one example close to my home here. The county south of where I live is Manatee County. And there, after Sackett, the county commission voted to weaken their mangrove protection laws. They voted to weaken wetland buffers um, against, there was huge public opposition to this. A couple hundred people came to the meeting to express their opposition, and the county commission was like, "Nope, we're we're going to loosen up the rules here." Next election, all five were voted out. So voting can make a difference. And I also urge you to think, right? Not just to think about voting for certain political leaders, but I encourage you also at some point in your career to think about running for public office because we need good people in public office. And so thank you for your attention. And That's again a picture of me and my students in one of my most favorite places in the world, in Big Cypress. It's always life affirming to emerge, not being bitten by an alligator. So thanks for your attention, and I look forward to your questions. Oh, you may be muted there.
I unmuted and then muted again. So we've got a few minutes left, and so we'll try to get to some questions here. But again, there is the connection for the book. Uh, Man, Roy, you have provided us with a lot to think about and a lot of scary things to think about. Certainly being a biologist, looking at how important wetlands are, the last thing in the world we want to see is deregulation of those areas. So we have one question from Keona. I hope that's correct. Given the current political climate, do you anticipate even further deregulation of environmental protections?
Sadly, yes. I think that's pretty clear from the executive orders that have come out. Um, so let me answer that first, of sort of process, and then I'll talk about substance a little bit. So with the executive orders that have come out from President Trump, um, that the president is not a king. The president can't simply say, here's a rule you must follow, people. Um, but what the president can do is direct the agencies to do something. And the agencies, if they are going to change the regulations or get rid of certain regulations, they have to go through a process. So, as I noted, a public notice and comment process quite often. So these executive orders give um, give direction to the agencies to start a process to deregulate. And we've seen that on a number of in a number of fronts. I think in the WOTUS area, I haven't seen anything pop out yet, but I can envision that that the Trump administration will be more explicit about this concept of indistinguishable, which the Biden administration did not want to address after the Sackett decision. And so I think that I think that we can anticipate that uh, that the Trump administration will engage in a further rulemaking, issuing a regulation that will reduce federal protections even further, which makes it even more important to focus on the state and local level.
And so, Stephen, just that kind of fits in here. Can POTUS have SCOTUS cancel the Clean Water Act?
Huh. Um, well, to some degree, SCOTUS has has scuttled a large part of the Clean Water Act. Um, which is, I mean, a tragic mistake in my view, because it's been such a success story. And indeed, even Justice Alito, in his opinion, he starts off by recognizing, before the Clean Water Act, many waters in the United States were fetid. They were fetid. They were not fit for use. Um, but because of the Clean Water Act, now they're fishable and swimmable. Well, wait. He skipped over the part about why were they in such poor condition and who was responsible. It was the states, and that's why why Congress decided to act and override a presidential veto in 1972. Um, so I so short answer is I think that the Supreme Court's already done the work for this particular POTUS. It may be, somewhere down the line, public gets outraged enough about harmful algae blooms from non-point source runoff from agricultural fields that perhaps we revise the Clean Water Act to deal with that. But in the interim, it's kicked to the states.
Anonymous asks, are there any specific case studies you would recommend reading up on of communities already feeling the consequences of the weakened water protection?
Mm. Let's see. I don't, so one example, I would say that the impacts haven't occurred yet, but one example would be in Georgia on the outskirts of the Okefenokee National Wildlife Refuge, where there's a proposal for titanium mining that initially needed a Corps of Engineers permit, and then after the Trump rule and after Sackett, it's clear that it no longer needs a Clean Water Act permit. So it was left up to the state, and the state is granting this permit for these mining operations that threatens the integrity of Okefenokee National Wildlife Refuge, which, like Everglades National Park, has been designated as a Ramsar site, as a wetland of international importance under a wetland treaty. Um, that is one to keep an eye on. Um, uh, but I'd also point back to what occurred in Manatee County, that voting can make a difference. And that another example, not WOTUS specific, but also comes out of Florida, is that we had a proposal coming out of the governor's office to um, put pickleball courts and some hotels in our state parks. And and people were outraged. It was bipartisan outrage where people were actually protesting at the state parks that they loved, and the governor backed off. It's going to require vigilance to make sure that these projects don't pop back again, but it was an example of where protest actually made a difference, and it was bipartisan protest.
We have a lot of questions, Roy, and unfortunately we're kind of out of time here. I'm going to try and grab maybe One more here. So Ben asks, will state enforcements of water-related issues be as effective as it has been at the federal level? Is it likely that federal entities can or will overrule state law or agency actions, or will state decisions be more independent of national decisions?
So I think with respect to freshwater wetlands and many streams, the state decisions are now going to be independent of federal oversight. And whether the states decide to step up and actually protect these resources is is going to vary. It's going to vary from state to state, and you'll have some states that I think will do a good job, and some states that will not. And if you're concerned about this issue, it's a matter of playing both offense and defense. So you want to protect the tools that you still have and try to get some more. So one of the things that some states may try to do is preempt local governments from protecting wetlands, and so that's something to watch for.
I think you just answered several of people's questions about what they can do. And I believe we'll need to close it at this point, but Roy, great presentation really opened up my eyes to a lot of the issues. I've just been fearful that we've been seeing the Clean Water Act being picked at and picked at and picked at. This is actually quite devastating to see what kind of impact these changes will have on wetlands, but certainly the downflow from that for biodiversity, even for wetlands and their protection of cities and other areas from climate change kinds of events. Um, Quite disturbing. I hope everybody will consider purchasing the book and certainly get involved. Get involved locally in your communities, the county, the state, and at the federal level. Your voice means something, so you need to make sure that everybody hears that voice. Thank you all for coming this evening. Thank you so much, Roy.
Thank you.
Good night, everybody.